All right, so Mr. Abiodun Owonikoko, Senior Advocate of Nigeria, joins us next to weigh in. Look, there's so many legal questions and clarifications and positions that lots of people want to hear you clarify, if you will. But good morning, and thank you again for joining us today. Now, just as I started, said, initially we did say so much is going on about this, the position that the federal government has taken and their agencies, which we will come to in a while. But give us your impression, your mindset about what is going on so far with this suspension of Twitter by the federal government.
Thank you. It was something we thought was flying a kite when the Minister of Information hinted at this possibility initially. However, it has happened. And unfortunately, I can see that there is lack of interagency harmony in terms of policy formulation and implementation in the present regime now. Why that is so, I cannot say. Otherwise, from what we have seen now, 4 government cabinet members ought to have been carried along in that decision. Information Minister, Office of Attorney General of the Federation, Ministry of Communication and Digital Economy. I emphasize the word digital economy. And the presidency. They ought to have sat down and looked at the wider ramification of the decision they were about to take, including, of course, the foreign minister. Because we are dealing with a medium that has global implications, global connections, and serious impact on the national image. That's why thereafter we have been seeing misconduct since. The Attorney General was reported to have said those who dared to breach the Twitter suspension directive will find out what law they are breaching when they get to court. The Honorable Minister of Information appears to have backtracked, saying that what they have done was not a permanent decision. At the end of it all, the foreign minister has had to be doing damage control, while the most pivotal ministry, under which you have NCC, that has direct mandate to regulate use of the social media through the internet, has actually been very, very quiet. What I've seen here is that we do not seem to understand the basis on which the Twitter business operates. The Twitter business does not provide content. It provides access for content to be broadcast. So when the Twitter handle as M. Buhari was registered, Mr. President was entering into a contract of use with Twitter, not as President of Nigeria, but as an individual just like any other person. Contrast that with what you have with the Twitter handle of the President of the United States of America, which is at POTUS. That is the Twitter handle of the President of America. So when President Trump's access to Twitter as an individual was suspended, it wasn't that of the President of the US that was suspended. It was his personal Twitter handle. The item of controversy here was posted under President Muhammadu Buhari's Twitter handle at M. Buhari. And what did Twitter do? Twitter, in accordance with their policy, which every subscriber has contracted to abide by, has a right to take down a content that either breaches their Twitter user agreement or their policy, which is an appendix to the agreement when you sign up as you are subscribing. So Twitter did not post a content, but Twitter has a right to edit content if it falls foul of their policy. That's number one point that we got wrong when we took on this matter and said we are suspending Twitter. For what? Twitter did not publish anything. Somebody posted his own information on his Twitter handle, and the owners of the platform based on their terms of use and policy, find some of the content to be to have run afoul. And so they took down that content. The same way they have done for the President of America, even as a sitting president. A country which actually licensed and incorporated Twitter and will regulate Twitter did not find it necessary, when that was done, to use the power of the state to harass or bully Twitter. Now, this is very worrisome because we have not seen the full ramification of what has happened. It shows to the world that our mantra of respect for rule of law is a charade. If a president or an officer under the office of president feels that the president has been personally embarrassed, then you bring to bear the full force of the state to deal with the aberrant institution, especially one that is not registered, regulated, or incorporated in Nigeria. We are giving the impression that what operates in Nigeria is rule of man rather than rule of law. And this is part of the indices that people look at when they want to come into your country to do business, to transact anything whatsoever. So it was a very bad optic for the country, whether we realize it or not.
All right, now, from what you've said, does that then mean that our position as a country, as a sovereign, doesn't come up here in the sense that you're saying it was the president's personal account, not his account, not the account of the president, the position of the president of Nigeria? Because if that were the case, will we have a case to say, well, the sovereignty of Nigeria, the laws of the country could be in jeopardy if we don't take certain decisions based on some of the things that we've seen published? Where does that come in here?
Now, it comes in where, for instance, the issue is having to do with national interest. And that has to be handled at diplomatic level. It is demeaning for a sovereign to start engaging in a spat with an ordinary company in another foreign country. This should have been taken up diplomatically, assuming this was a national interest issue. You don't engage a whole sovereign with an ordinary company in another country that's subject to FCC's direction, Federal Commission direction, another agency like NCC. The Nigerian government now is now battling with ordinary company, regardless of the size and capitalization of that company. We are demeaning our country. If it is a national issue, then we should have used the diplomatic channel to take that up. Take it up with the American embassy. Then they engage their own. They will not even, America will not go to Twitter. They will go through the agency that has authority to superintend the operation of Twitter. And then something will be done. But we have approached it in a way that looks so puerile, so childish, that we don't project the impression that we are a serious country, that we are, and so this is worrisome. That's the first side. The second point I wanted to make was about the fact that we are no longer living in an age of IT. We are living in an age of IoT, Internet of Things. It's not only human beings now that communicate. Things are programmed to communicate using technology. So when we are focused on just addressing one person's misdemeanor, misuse of Twitter, we are not appreciating the level of technology that is available globally now. Look at what we have seen. After government made this announcement that is suspended stuff, which they don't have power to do, they have power to restrict access of Nigerians to use of Twitter as a platform, but not suspend Twitter that Nigeria never licensed in the first place, and Nigeria has no power to regulate. If you look at the Constitution of Nigeria, under Section 39, under freedom of expression, the right of access of every citizen to platform for expressing themselves is generally guaranteed. But there are provisions under subsections 39, 2, 3, and 4, where those rights can be abridged. And they can only be abridged in accordance with an act of parliament, not as a matter of regulation or policy or disposition of a government functionary. This also is not the impression we are creating the way we have gone about this problem. Twitter is just a company, just like NCC, MTN, Airtel. Why have we elevated to the point where Nigeria is now engaging in diplomatic competition or contest with ordinary company in America? We are reducing our country. The president of Nigeria, if he feels strongly, can take it up with the president of America. Not for Twitter and Nigerian government to be debating about what's right when we don't have no control over his business. So it is therefore my advice that time has come for us to beat a retreat, eat the humble pie, and go about this properly. I'm sure as a responsible corporate citizen in America, Twitter also must have learned a lesson from this. To be fair to government, there has been a number of posts on Twitter that you will expect them to apply the sledgehammer the same way they applied to Mr. President's own post, which didn't appear to have happened. And so government is entitled to feel that there isn't an objectivity in the way Twitter enforces its rules, and it's like Nigeria is targeted. That is a legitimate concern, but we must not correct a wrong with another wrong. Two wrongs do not make a right.
Let me just pick it up from the point which you made earlier about rule of man rather than rule of law, and you spoke about the implications, wide implications, as it were. But from what we've seen so far from the government, it would seem the government is not backing down. I mean, the suspension was issued on Friday. It took effect on Saturday. You saw the Attorney General's statement. You saw statements that came subsequently. You referenced the one from NBC, the Ministry of Information. In fact, the Foreign Affairs Minister also spoke yesterday, and there was another clarification from his ministry saying that, well, they didn't give conditions. But clearly, it would look like the government is not backing down on this. But you say it is time to eat the humble pie, as it were. In what shape, in what manner should that eating, that dining look like?
Thank God, we still have a very robust and professional foreign service. When matters extend beyond our territory, it is the job of our foreign service to manage the fallout. It is not the job of a propaganda machine like the Minister of Information to do that. It's already beyond them because they have escalated the thing beyond their remit. So I hope government appreciates what this implicates. I've read in the paper how much Nigeria is losing on a daily basis on account of this supposed suspension of Twitter. I've said it before and I'm saying it again. Nigeria has no power to suspend Twitter. The power we have is to suspend access of Nigerian users of Twitter to Twitter facilities, to Twitter platform. So you can see already that in terms of terminology, we have adopted the wrong expression. You cannot suspend an organization from operating when you don't have the power to license it to operate. And Nigeria has not licensed Twitter. What they have done was to license communication companies in Nigeria to access Twitter, broadcasting corporations to use the platform of Twitter for the public to access them. So that is what we should have said we were suspending or we were restricting access to. So when you say you are suspending Twitter, you make yourself a laughing stock. This is a digital platform that's operating in the cloud. So I would urge the president at this stage, because this has become a serious matter. If you look at what's happening, it's no longer an issue of North, South, West. It's a matter of generational distrust now. A lot of the younger generation who have managed to develop a new form of economy around the digital technology are feeling done by this decision. Institutions, small businesses that thrive on using the platform of Twitter to drive their businesses, earning daily living, are now grounded because some of them, they attract market and patronage outside of Nigeria, even though they are located here. People use their facilities, PayStack, Flutterwave, all these payment systems, and a host of other IT-dependent businesses that our young people have created in the last 10, 15 years are now suffering just because somebody somewhere in the presidency or in the ministry, cannot develop the thick skin to overlook some things. In any event, let us look at what has happened. Twitter did not even take away the account of Mr. President, unlike what they did to President Trump, who is the president of the country where they are legislated to operate. They just took down an aspect of a publication which they believe offended their policy. And so when you sign on to their contract of terms of contract, you are deemed to understand that these are the rules of engagement, which you will abide by. Don't forget, People don't know. The use of Twitter itself for business is free. Nobody pays to be on Twitter. It's only when to make use of their commercials, the commercials with their business, that you pay for it. And by the law that established Twitter, the maximum you can get for damages when they offend their terms of engagement is the amount to pay for using their service. Now, if the service is free, you can't even get to sue them in the court of law. At most, you get maximum of, under their contract, $100. Can you imagine a whole Nigerian sovereign paying Twitter for something like this, and all you can get, which has to be probably in an American court, is $100. It shows you how pedestrian the debate that we are engaging in has been. It's so unfortunate. We have too much to bother us. We have so many challenges that even Twitter is one of the strongest weapons we can use to address. Reaching out to the public at instantaneous time frame with positive information from presidency, from government agencies, is something that Twitter has provided us avenue for. Why can't we harness that for that purpose, rather than be concerned about the other side? If there are more positive information coming from government through Twitter and the negative coming from some harebrained people abroad, with time, those guys who found that Twitter platform is no longer helpful to their cause, they will move, they will migrate, and they will have to succumb that place to government. But government must populate Twitter platform with the positive information that Nigerians are going to be happy to read about. That is the better way than to start engaging in a fruitless battle with Twitter.
Well, there's something you said earlier, Mr. Owonikoko, that in fact, so many things that you said that I would love very much, to get a little more understanding on. For instance, you mentioned the individual of the president as opposed to the institution of the presidency right now. I don't know how many people will be able to internalize that. But there was something you also mentioned about the fact that it's not cultural, it's not ethnic, it's generational. Do you think this understanding is lost or not on the authorities and even the generation that we're talking about? Does it look to you like it's an attack or a deliberate targeting of a particular generation?
I don't think it was deliberate. I believe that the full ramification of the consequence of that decision did not occur to the government functionary until the backlash came. And that's the more reason I'm saying that if we got something wrong, humility is not a vice. Actually, it's a virtue. You build trust when people realize that even when our government gets it wrong, it admits its error and corrects its ways. This is the time to do that. I just recall how much the vice president, in terms of time, spent, I think the year before, going around distributing trader money of 10,000 naira or something to traders all over, just to get people employed. I know how much was voted for this special job thing that Keyamo SAN, Minister of State for Labor. But combine all of that together and aggregate it. It's not up to what the Nigerian younger generation in IT-dependent business have lost in the last 3, 4, 5 days. So if we realize that there is a way to do damage control without government losing face, there has to be engagement. For instance, one of the things I'll propose now, Minister of Communication and Digital Economy should immediately convene a special session with the digital economy space, especially the generation X, to determine what has this cost Nigerians and what are their ideas about how to navigate out of it. If that starts to happen now, that is a constructive move from government that will restore belief that government feels for them. Because in another 5, 10 years, these are the people that will take over this country. And we must prepare the foundation for them to successfully succeed us. We thought we were young, now we are getting old. Our children are challenging us at home. And with this development, information about Nigeria has gone even more global. People that ordinarily were not interested, not even Nigerians, those who are just fans of the country, are getting to now read so much on Twitter under the virtual private network option than they would ordinarily be interested in. So the country is in the eye of the world, and the information and the image you should project now should be constructive and positive. And that probably is the opportunity in what has happened.
Is that okay? Go ahead.
Yeah, I was going to ask you. Look, there's a the memo that was circulating from the National Broadcasting Commission to broadcast houses about the suspension of suspending their Twitter handles. And the second paragraph, they say, in compliance with the above directive, broadcasting stations are hereby advised to deinstall Twitter handles and desist from using Twitter as a source of information gathering for news and program presentation, especially phone-in. Section 2, Sub 1R of the NBC Act entrusts the Commission with responsibility to ensure strict adherence to the national laws, rules, and regulation, and it just goes on. Is this within the laws of this country for this to happen?
Thank you for asking that question. But it's evident that while the Minister of Information is himself an accomplished lawyer, the pool of politics has beclouded the handling of this matter. What they have done is what is called in law prior restraint of information. You are preventing, it is not Twitter you are preventing from exercising their right. It is the individual who has the right of freedom of expression that you are preventing from exercising that right when you give this kind of directive. The only instance, there are instances where this can be justified. And this started as far back as 1971 in US. New York Times or United States case of the Pentagon paper. And this was where Supreme Court of the US had to come down on the principle of proportionality, the rule of clear and present danger, which allows the state, through the court, to prevent certain information from being distributed to the public on grounds of either national security or public morality. But the test and the body of establishing that is justifiable is on the state. So usually what should happen is you approach the court and indicate to the court that this information is about to be released to the public and it is injurious to the health of the state and security. The court authorizes you to then pass that directive, which all media organizations can comply with. But you must first justify it. What we have done is to reverse the order. In fact, not even reverse it, to create a parallel regulation and regime. Don't forget, and people must be clear, it's unfortunate that President Buhari is being made to reintroduce the mindset that led to problem for his regime in 1984. Decree 4, if you remember. That Decree 4 is the equivalent of what the Minister of Information has done now, which prevents the publication of information that embarrasses people in government, even if they are true. You remember the Guardian duo that had to be jailed for publishing what indeed was actually true, but because it embarrassed government. It's the same thing they are doing now, even without the backing of a law. So the only laws I know today that allows this kind of restriction is either you go under the Cyber Crimes Act and Terrorism Act or the General Criminal Code. Outside of this, you need to get a new legislation. We attempted this 2 years ago, don't forget. There were two bills that were sponsored, the hate speech bill and the one on social media bill. These two bills failed to pass in National Assembly. What the Minister of Information is actually doing through NBC now is to implement a law that has not been enacted. Those two laws will have made it possible to do this. Even then, in those provisions that did not pass through, there was a requirement, a rigorous requirement to satisfy before you can restrict access of the public to social media and public broadcast media to express their views. So I believe that directive of NBC is ultra vires their authority. And in order not to create a state of anarchy, some public interest litigators should challenge it in court. I know it's difficult for broadcast houses who are subject to a regulation to challenge them, but other interest groups can't actually challenge that directive. And that way, probably the law would get some clarification. But certainly, I have my strong view that directive of NBC is not defensible, either on grounds of national security or not public morality. To say that My brother who is in a village and has little access to telecoms by way of Twitter should not be heard on channel television when he cannot travel all the way to Lagos or Abuja, where channel television is to deprive him the right of freedom of expression. And you are doing that before you even know what he's coming to say. Not that you already know that what he's coming to say is likely to breach national security. You are preempting his expression of his views. And that is contrary to Section 39 of the Constitution that guarantees freedom of expression and impartition of opinions and ideas.
Very interesting perspectives, even though lots of people are already saying, wow, that they don't mind having you back. But we have to thank you very much indeed for coming on this morning, Mr. Abiodun Owonikoko, Senior Advocate of Nigeria.
It's always my pleasure. Have a nice day, sir.
All right. Well, back in a moment, we'll still have another matter here, so don't go away.